Let's talk about community property and community property with rights of survivorship. If you work with married clients in Nevada, these concepts are critical. They often affect ownership, probate, and long term consequences in ways many people don't realize. Community property is a form of ownership available only to married couples. Property acquired during marriage with community funds is presumed to be owned equally by both spouses. Each spouse owns an undivided one-half interest. When property is held as community property without survivorship language, each spouse owns 50%. There is no automatic transfer at death, and the deceased spouse's half passes through their estate. That means probate or trust administration is usually required, and this surprises a lot of people. Community property with right of survivorship combines the community property ownership structure with automatic survivorship at death. When one spouse dies, their interest passes automatically to the surviving spouse, and probate is avoided for that property. This transfer happens by operation of law, similar to joint tenancy, but with important differences. Community property with rights of survivorship is popular because it preserves community property characterization, avoids probate at the first death, and often provides favorable tax treatment compared to joint tenancy. This makes it especially attractive for married couples holding major assets. Community property versus joint tenancy. This distinction matters. While both can include survivorship, joint tenancy treats spouses like unrelated co-owners, where community property recognizes their marital economic partnership. They are not interchangeable, and the deed language must be precise. Community property with right of survivorship must be explicitly stated in the deed. Typical language includes, as community property with right of survivorship. If survivorship language is missing, the law will not infer it. Problems arise when couples assume survivorship exists without stating it, when deeds use joint tenancy language when community property was intended, or when property is refinanced or transferred and survivorship language is dropped. One missing phrase can change the entire outcome. As a document preparer, you may include CPWROS language when directed. You may explain how it works at a general level. You may not recommend one marital property form over another. If spouses are choosing between joint tenancy, community property, or community property with rights of survivorship, that decision requires legal advice. Big takeaway for this section. For married couples in Nevada, community property defines ownership. Survivorship defines what happens at death. Community property with right of survivorship combines both, but only if it is clearly and correctly stated in the deed. In the next module, we'll look at why tenancy choices have long-term consequences and how small drafting decisions today can create big problems years down the road.
This video is provided for general educational purposes only. It is not legal advice, and it does not take the place of advice from a qualified attorney. Laws and requirements vary by jurisdiction and by individual circumstances, and watching this video does not create an attorney-client relationship with Nevada Counsel. If you need guidance about your specific situation, you should consult a licensed attorney in your jurisdiction. Thanks for learning with us.